Good afternoon, everyone. For everyone who has just joined us, whether you're here in person or virtual, welcome to the 2022 Riesenfeld Symposium. Our next panel is titled Antitrust Enforcers, A New Era of Global Regulation. Our moderator is Professor Aaron Edlin. Professor Edlin is the Richard W. Jennings Professor of Law and Professor of Economics at Berkeley. Professor Edlin is a leading expert in antitrust economics, antitrust law and economics. He has published articles in leading law reviews. He has published a leading case book, and he has formerly served in several roles with President Obama and the Clinton White House. Professor Edlin, I'll let you take it from here.
Okay, well, we have an illustrious panel here with three luminary antitrust enforcers from around the world. And also Sylvia Dettar, who is a Berkeley law graduate and practicing in the private antitrust bar in Germany, and will no doubt be a luminary on one side or the other of these antitrust cases in the years to come. She represents the future, I guess. At any rate, I want to thank everyone for coming, and we're going to be discussing antitrust from around the world, and we have Patty Brink, who's here from the US Department of Justice, and we have President Alex Cordeira from Brazil, and Vice President Henri Pifot from the French Competition Authority. And I apologize if I have butchered anyone's name. Feel free to correct me for the audience's benefit and my own momentarily. So I'm hoping that you could each just begin by telling us a little about your role in your organization, and also your organization's role in competition law, which is the international term, or an antitrust law for Ms. Brink, which is the US name for the practice. So why don't we start with Brazil and President Cordeira? Can you tell us something about what you're doing down there?
Thank you very much, Aaron. It's a pleasure to be here. Thanks for having me here, and see a lot of friends, Patricia, Sylvia, and all of those guys. Thank you very much. Kaiju, the Antitrust Agency in Kaiju. First, I think that it would be a good idea to explain a little bit about the structure of the agency and the things that we have been doing here in Brazil. So Brazil is very active in antitrust. So Kaiju has been growing since the new antitrust law here in Brazil that took place in 2013. And we started to develop a lot of things here, especially giving power to the agents. So, and the structure is quite interesting, because if you see inside of Kaiju, you have two independent institutions in Kaiju: the General Superintendent, that works like the investigation body, and also have the tribunal. The General Superintendent, that's one guy that, run the place, is appointed by the President of Brazil and has to be confirmed by the Senate. And the other side, we have the tribunal. They can review the decisions from General Superintendents, and they are formed by 7 people. One is the president, and the other 6 are the commissioners. And also, they are appointed by the Brazilian president, and they have to be confirmed by the Senate. And they have a mandate, a term. And this term is 4 years. So nobody can take they out of the job. So they are completely independent. They vote how it doesn't matter, each way they go, if it's against the government or not, they have independence to do that. And usually, and this is a little bit different from the United States, usually they start the term and they finish the term. They don't give up or they don't, leave the place until the end of the term. So this gives us quite independence, and also Kaiju is famous because it has a lot of transparency. Why is that? I think that we are the only jurisdiction that our sections are in YouTube, but the whole thing, and not just the part. If you want to watch the Kaiju sections, you go Wednesday, 10 a.m. Actually, we have a section tomorrow. Just go 10 a.m. Brazilian time. You see everybody talking about the cases. And we talk about everything. We discuss the harm theory, the evidence that we find in the case. And this gives us a lot of transparency and also give the opportunity for the society control what we are doing. It's much more hard to take wrong decisions when you have a lot of transparency than when you go in a room, you agree with the terms of the decision and come back and give just the result. In Kaiju, it's different, for example, from FTC. We don't have consumer protection role. We don't have data protection. We don't have FCPA, nothing. We have just antitrust, just competition, merger and acquisitions, fight against cartels, and also abuse of dominance. That's what we do in Kaiju. And we also do have like 2 ways to do that. Actually, 3 ways to do that. What we say that we work in advance at controlling the structure of the market. We will analyze every merger and acquisitions that happens in Brazil since when they reach our requirement, that is the income requirement. And also we are trying to avoid the conduct that can cause harm for the competition. And the third one is the advocacy role. And today we think that this is one of the most important role that we're playing right now. Because if you can do a very good advocacy together with the sector agencies, we will have a lot of success, decreasing barrier of entries, organizing the market, and, explain what should be a very competitive market or not. So these are the main things in Kaiju, just, to have an idea. I know that we have a lot of people to talk, and I'm sure that the time is not so long. So I leave it here. Thank you very much, Aaron.
Thank you. That's an excellent introduction to Kaiju and your work there. How about moving to the US DOJ?
Sure. So first of all, thank you very much for having me. I am a proud graduate of the UC Davis Law School, just down the road from you guys. And I will admit to having spent a lot of time at Berkeley, because when I was a first year, I started going out with my then boyfriend, now husband, who was getting a public policy degree at Berkeley. So we spent a lot of time on Interstate 80 between those two towns. So thank you for having me. I also have to do my traditional disclaimer, which is to say my views are my own and do not necessarily represent those of the US Department of Justice. So I came actually to the Department of Justice directly from graduating from UC Davis Law School. And I stayed in the antitrust division since. I've had a lot of different roles, including 10 years as the director of civil enforcement. And my current gig is I'm senior counsel working primarily on international issues and intergovernmental engagement. So I think, first of all, just in terms of if people aren't familiar with sort of the basics of how the competition laws are enforced in the US, I have to acknowledge that we do have a sister agency, which is the Federal Trade Commission, that shares jurisdiction with us for very much enforcement of very much the same laws. As President Cordero mentioned, the FTC does consumer protection, whereas like Kaiju, DOJ does not. But on the other hand, we do criminal enforcement of cartels, and the FTC does not do that. Otherwise, the jurisdictions are very similar between us and the Federal Trade Commission, which primarily breaks down, quite similar again to Kaiju, into 3 different types of cases that we bring. One is we look at mergers to see if they're likely to harm competition. We also bring cases against other types of conduct that would affect competition. And then we also enforce criminally the Sherman Act for agreements between competitors that are sort of hardcore cartels is what we tend to call them. In mergers, we're typically we're enforcing Clayton Act Section 7, which was passed in 1914 to stop a lot of the trusts that were such a problem at the beginning of the 20th century. And in mergers, we're usually looking to see if a merger would allow the companies to either raise prices or otherwise, decrease quality or otherwise decrease the level of competition and harm consumers. So examples of that, right now we are litigating a number of merger challenges. I think one of them that's really interesting is the Penguin and Random House, who are both book publishers, are merging. And there we're looking to see whether that merger is going to allow those publishers to pay authors less, which is a sort of different kind of harm to consumers, but it's something that's really important. We've litigated mergers, a while ago, we blocked 2 mergers that would have decreased the number of health insurers in our country from 5 to 3. And we successfully had, long trials on those mergers and were able to block them. On sort of an example of what we call the civil non-mergers cases would be the case that we're doing right now against Google for illegally maintaining their monopoly in the general search area. We also do, as I said, cartel work. And I think a terrific example of that is some cases that were brought by our San Francisco office, which was in the packaged seafood, which is also known as cans of tuna. Turned out Bumblebee and Starkist were price fixing tuna for years. And so they found out about it, they prosecuted it, got fines. I think one of them was $100 million fine. And also in the US, and this is a little different than a lot of other jurisdictions, executives can be held criminally responsible and go to jail for price fixing. So there was an executive, I think it was for Bumblebee, who was sentenced to 40 months in jail for his role in this price fixing conspiracy. And just to sort of finish this up, the thing that's a little different with the US DOJ than a lot of other agencies around the world is that we bring cases and we need to file them in federal court for them to be prosecuted. There are a lot of agencies that are administrative agencies that can issue decisions. We actually have to take it to court, and if it's not a settlement, then we'll have to have a trial and prove up our case to a judge. So that's just something that's a little bit different. So I think that sort of gives you the lay of the land for what the enforcement of the competition laws in the US.
Indeed. I guess even if there is a settlement, you have to take that to court and
absolutely to make
that
it
cleared as being in the public interest under the Tunney Act or something.
Right,
like that.
and then it's only enforceable when the judge enters it and becomes a judicial order. That's exactly right.
And occasionally the judges will say, "No way."
Yeah, pretty rarely, but they ask some questions.
Yeah, there was one back in Microsoft, I think. Okay, why don't we, thank you. That was super informative and excellent. Why don't we go to Ms. Tatar and have a change of pace and hear from someone who's saving firms from overzealous enforcement.
Well, thank you very much. Thanks also very much for having me here. I'm humbled to be here among all of you. My name is Sylvia Tatar, and I'm an associate at Cleary, Gottlieb, Steen and Hamilton LLP, which is a big firm, an international firm. And I'm a lecturer as well at the University of Marburg. I would say that most relevant to this panel, I've also worked on a few cartel investigations in the appliance and in the car parts sectors, but I've worked a bit more on big mergers. So Dow and DuPont's merger of equals. On that one, I focused on clearance before the European Commission and on Thales's offer for Gemalto. And on this offer, I focused on clearance before the rest of world. So what this means is not the clearance before the European Commission and not clearance before US authorities. In this case, it was the DOJ, but instead coordinating all of the authorities around the world. And as Professor Edlin mentioned, I did go to Berkeley Law and I served as lead online editor for BJIL. I'm really impressed to see all of the energetic and ambitious projects that are going on with BJIL today. There's a podcast now. That's pretty cool to see. So thanks a lot for having me. I'm really humbled to be here.
Okay, well, thank you. So how about Vice President Pifot? You're Vice President of the Competition Authority in France. Maybe you could tell us a little about that. And I guess you worked at the European Commission before.
Indeed. Well, thanks very much. I'm also very humbled to be here. Can you hear me okay?
Yes, yeah? I can hear.
So I thought I would present a little bit how competition law is implemented in Europe, because it's a bit different as a system compared to the US or even to Brazil. Before I describe the French authority and my role into that. So I would say there are three peculiarities of the European competition law system. First, it has an additional leg compared to other competition authorities. We deal with considered practices and abuses as others. We deal with mergers as others. We have a strong advocacy role, not only vis-a-vis the private sector, but also vis-a-vis governments when they intend to present laws or reforms to the working of some markets. But also we deal with state aids at the European level, from the European Commission perspective. State aids, basically public money being spent to help private companies and visa control, because there's a fear that would distort the way competition works in the markets, and that would go contrary to the aim of integrating markets in Europe. So that's one peculiarity. The second one is that it is an administrative system, as Patty just mentioned, meaning that we adopt decisions. These decisions may be challenged before the courts, either national courts when it's a national competition authority, or the European courts when it's by the European Commission. But that changes completely the way the system works compared to having to file a complaint, for instance, or consent decree. And lastly, the third peculiarity is that there's an architecture of who deals with what at the European level or at the national level. So speaking about considered practices and abuses of dominant position, these can be dealt either on the same legal basis, either by the European Commission or by the national competition authorities. And there's a system to make sure that it's the right agency or the right agencies who are going to deal with such cases. The same goes for merger control, even if the law is different at the European level and at the national level. And again, for state aids, it's only applied by the European Commission or judges' courts. So, having described that, what's my role and how does the autorité de la concurrence, we say in French, how does it work? It has because it's an administrative system, there is always a risk that those who have investigated the case may have a bias at the end of the day and may lead to to the adoption of a decision which may not have fully heard what the other parties, when they exercise the rights of defense, would have said. So at the authority, there's a distinction, there's a separation between first the investigative services, those who do the investigations and draft the first term sheet, let's say, about the objections that they may rise against a practice or a merger. And then the decision body, which is the board, the collège, we say in French, where I sit. And the collège would take over the case once the statement of objection has been sent, and then we chair a hearing, and then we decide on the case, and we draft the decision. And that separation between the investigative services and the board is a very sound measure in here. So what's my role? I'm a vice president, so part of the board, and my role is I would say a bit equivalent to a administrative judge in the US. Voilà.
Thank you. Well, my next question is I was hoping to learn a little bit about the current priorities of your enforcement agencies. Why don't we switch order and hear from Vice President Pifot. What are the priorities of the French Competition Agency right now?
So it's a tricky question to answer. I would say that, I mean, there are different ways to define priorities. One priority is basically to deal with cases as quickly as possible, because we have a tendency to try to have the best possible cases, but that takes time. Another priority is really to expand the what I would call the culture of competition to all economic sectors in France. There are a number of professions in the health sector, or in speaking about, I don't know how you call that in English, bailiffs or notaries, which have been recently deregulated, and where there is really a need to make sure that the deregulation is given full power, so that the competition would bring benefits to consumers. And another priority that we have is really to try to adjust our practice to the digitization of the economy, not only the digital giants, but also the fact that the economic business, the way that a number of businesses work has fundamentally changed, and therefore the way competition works as well.
Ms. Brink, could you tell us something about the DOJ's priorities at the moment? A lot's been happening, is my impression.
There is a lot going on, and I think I would echo Henri's thoughts about doing cases efficiently and thoroughly, and enforcement is always a priority. I thought it might be interesting, though, to talk about on the advocacy side. We have a new executive order from President Biden that was signed last summer. And what it does is really sort of what Henri was talking about, is trying to create a culture of competition within the federal government. And the executive order, that's called like Promoting Competition in the American Economy, is really all about highlighting for the different agencies everything that they should be doing in taking competition into account, along with the particular areas that they already focus on, and because all of the regulatory agencies have various mandates, the FCC, Federal Communications Commission, has to worry about sort of the reliability and access to underserved communities. And so it's really an effort to make sure that competition is playing a role and being taken into account by all these different agencies. I think somebody counted on this executive order and saw that it imposes 72 specific obligations on 14 different federal agencies. And, like other competition authorities, we've always worked with, sectoral regulators because usually they have some oversight of different things that we will work on, such as mergers, but they usually are looking for different types of things. You know, we've worked a lot with Department of Transportation on airline mergers. You know, we've worked with the Federal Energy Regulatory Commission on electricity mergers, but the executive order is really requiring them to report on what they're doing to make competition a part of their rules, a part of their processing. There's actually a competition council that's hosted by the White House where, and I think, you know, they've already had, I believe it's either 1 or 2 meetings of the competition council where they are cabinet level meetings where the secretaries of the agencies go in and report to the president about what they're doing to make competition a part of their rulemaking, to make competition a part of what they're looking at in regulating all of the different entities that they regulate. So, you know, we're working a lot with the USDA that regulates a lot of agricultural markets to say, how can you sort of infuse more competition into them? And we're working with a lot of these different agencies. And frankly, this executive order is really a bit of a sea change in promoting a culture of competition throughout the whole department. And I think that's a huge priority for the department right now.
Wow, interesting.
Mm-hmm.
Well, that is a big change from my short stint in Washington 25 years ago or something, when there was exactly one cabinet level meeting on competition and antitrust. And it was, I think I could say at this point, I think it was quite, the FTC and the DOJ were trying to beat it out of the cabinet because suddenly the White House was getting involved and it was very unwelcome. And they succeeded in getting everything back to the agencies after this one meeting, which kept me in the White House a little longer than I planned.
Patty, can I interject and ask, I've heard a little bit, maybe coming from this EO, about anti-racism, antitrust enforcement. And I'm curious, how does this come into the various different agencies, or where is this headed?
I think that's a really tricky question. And I bet Henri might have an opinion. There's a lot of questions of what should be the goals of the antitrust, of the competition laws, and whether, you know, there's sort of been this focus on, you know, what we call the consumer welfare test, which has to do with looking at how, whether it's a conduct or merger, how it affects consumers primarily to the point of view of affecting prices and quality competition. And there's a lot of people are doing a lot of hard thinking about how competition law can benefit a variety of different interests. There's a lot of work going on right now on labor markets. Mm-hmm. There's also sustainability, and there's some thinking about sort of the racism. And I don't really know too much about it, and it's something that's largely being written about. You might have more to say on it.
Do you want to take that invitation, Ms. Tatar?
Well, I suppose it is something that I'm curious about. I suppose just thinking about how different opinions on how should antitrust or competition authorities go. Should they be, you know, very purely evidence-based, economic? Should they have some popular thought in coming into consideration? And also, how do we quantify different types of economics or inefficiencies and so forth? And so I guess I'm curious to see where this will go and what hold it takes.
So can I jump in here?
Please.
So just to tell what Brazil is doing and what we have been thinking about this. This discussion is also big here in Brazil right now, but we tend to be more orthodox. We tend to be more traditional and stay with the welfare standard consumer, with the consumer welfare standard. So The idea is we're still using a lot of economics in our analysis. And we think that if you open this box of everything that sustainability, labor, or whatever it is, first of all, we don't know how to do this. I'm not saying that is not important, and also that competition will not affect those areas of social things or labor or environment. Maybe they will, but I don't think that primarily we have to think about that. I think that we have to think about efficiency, the consumer welfare standard, and if beside that, our decision protecting the consumer, the efficiency can help also sustainability, labor, whatever, this come with our decision, but not has to be the main issue of our decision. And we have some cases that can be a good example. I have a case in Brazil, a merger and acquisition, that the efficiency was fire almost 10,000 people. That was the efficiency. And we approved the deal and say, okay, we'll be approved because of this efficiency. I'm not saying that is a good idea, fire 10,000 people. What I'm saying is probably there is better people to do this in Brazil than the antitrust guys. So this is what we have been thinking about. I know that this discussion is huge. Go to the new Brundisian's theories or stay with Chicago School. We're like, in the middle of that. But also, I'm very comfortable because I know that Brazil is not leading the world. So I can wait Patricia Brink's do things in DOJ and also Lena in FTC and the people from DigiComp, and we can watch and learn with them as always we have been doing so. And they always are a good teacher for us here. So this is what's happening in Brazil right now.
Thank you. I was wondering if we could talk about mergers for a little bit. I have a few questions about mergers. One question is, if you have two large multinationals that merge, the merger may get reviewed in a wide variety of jurisdictions. I think, Ms. Datar, you were telling me yesterday you'd worked on some that were reviewed in 27 jurisdictions. Was that right? Or something like that?
It's not one that I worked on, but when some of my colleagues worked on, the Siemens Alstom would have been reviewed in 27 jurisdictions had it cleared.
Right, which is just wild in a variety of ways. I wonder a few things. One is, how many jurisdictions do you think, for anyone on the panel, effectively have veto power over a large multinational merger? I presume the US and Europe do. I mean, of course, the DOJ doesn't itself, but if they challenge it and succeed in court, then the merger won't happen. Does anyone have a sense of who can stop a large multinational merger other than those two? Or are there lots of other countries? Can Kaiju stop a large multinational merger?
Yeah, I mean, I think that every jurisdiction is completely independent. I mean, if this like huge merge, multinational merge has operation in Brazil and will affect the market, we can block, and we have done in some cases, sometimes not block completely, but also applying some remedies, and maybe some remedies can, cause so many problems for this operation that we call like a blank blocking operation. So it's we just sometimes if you apply a remedy that is so strong, you can block the whole operation. I know that Brazil sometimes is a very big market. We're talking about the 7th or 8th economy in the world. So 250 million people, many of those companies are worried about notifying Kaiju and have the proving from Kaiju. But also, we know that we are inserted in a globalized world, and that's the importance of having a very good international cooperation, as we have with DOJ, FTC, DG Comp, GFK, KFTC, GFTC, actually, the people from BRICS countries as well. So we talk to everybody because most of those deals, they have been notifying around every jurisdiction. And we have to talk to them to do the time alignment, see if they have waivers, change of evidence, and I have a very good example, Siemens and Alstom. This case was blocked in Europe, and in Brazil, the case was completely different than Europe. We have just in one of those markets, just one problem in one of those markets, that if you do a small remedy structure or maybe behavioral remedy, we could solve the problem. But we decide to hold the case, wait a little bit, and see what Europe will decide. And this is a very good idea because we didn't influence anybody. It stayed like holding the case. When Europe decided to block the case, our case was also solved here in Brazil. So, and we do this a lot of times. Bayer Monsanto was a very good example of international cooperation. And so we cooperate with the United States, we cooperate even with Russia, and we cooperate a lot because they have a little different views of the cases, but was important for them to know what we were doing here in Brazil. And we have to combine the remedies and see that we're inserted in a global world. We cannot take decisions just by our head here, even if you have completely independent agents, but it's a good idea to cooperate and understand what's happening abroad.
So what does cooperation amount to? I often hear about agencies cooperating, but if one agency wants one remedy and another wants another remedy, do they compromise, or can't they each insist upon the remedy they want? What for anyone, what does international cooperation in one of these cases look like? And why does it?
Henri, you want to take that or me?
So I'll give it a try and then you complement, okay?
Okay.
So what does cooperation look like? There are different levels of cooperation. So you have measures which meet the jurisdiction thresholds, both say the US and in Europe, and then there might be a cooperation based simply on let's say public facts or public theories that on the impact that the measure may have. But most of the time, what the parties do is that they provide waivers so that both, say, the DOJ and the European Commission, the DG Competition, may exchange confidential information. Once we have such waivers, then we are able to really exchange in-depth our views and our analysis, or even documents that we have got from the investigations. And at the same time, once we may be able to be on a par on the various possible theories of harm, there's a way to adjust our timetables on both sides of the Atlantic. Now, cooperation may have different impacts depending on the markets, the size of the markets, the geographic size of the markets, which are impacted by the merger. If it's, say, a European market, and then on the other side of the Atlantic, it's a US market, then there might be similar theories of harms, but the remedies might be completely different because these are different markets. If it's one single worldwide market where, say, there would be a plant which is based in the US, which supplies the whole of the world, then obviously you need to have a a common remedy, and you need to discuss and make sure that the remedy is going to solve both problems on both sides of the Atlantic. It depends very much on the case, on the definition of the relevant markets, and on the way these businesses are built.
So
Patty, do you want to build on that?
So I understood that you want to share information and analysis and theories. And then where I guess I need help was at the very end with you need a common remedy. So can you give an example that could help me in the audience in understanding the need for a common remedy, as opposed to, you know, the US wants its remedy and insists on that, and Kaiju wants their remedy and they insist on that, and France wants its, and the EC wants its, and the company has to do all of them.
So if I can jump in.
Yeah, please.
I mean, I think what you're really highlighting is one of the main reasons why we cooperate, which is the real problematic outcome of merger reviews in a lot of different jurisdictions is the possibility of inconsistent remedies. And we are always, you know, I think, you know, Henri sort of talked about the ways in which we cooperate. You know, our teams start, you know, particularly after they get waivers from the parties that allow them to discuss the confidential information that the parties have submitted to us. After we get those waivers, we are going to be talking to other agencies and have team-to-team discussions that might be once a month, might end up being weekly. And there's a lot of discussion about what people are finding out about competition in that particular area. And, you know, I think, you know, President Caldera talked about the Bayer Monsanto, and I think that is a perfect example of coordination between a lot of different agencies, and where the remedies, everyone recognized that the remedies needed to work together. That even if it was a seeds market in the US that was different for corn seeds sold in Iowa, that some of the R&D on that was being done in Germany, you know? And so the remedy really had to work together, and people recognized that and work very hard to make sure that the remedies work together, whether they're really identical or not, because you can't have a situation where merging parties are required to sell things off, different things in different countries. You know, I mean, sometimes that happens and sometimes that works, but usually on these very big multinational mergers like this, you really need to coordinate the remedies, which is not to say you're compromising. I know you were sort of
okay. So could you just give me a little bit more flavor, if you're able, on this Bayer Monsanto thing about the nature of the inconsistency and the need for cooperation to conquer it. So
I mean, it wasn't. I mean, I felt the sort of example of R&D being done on one continent for product that's sold in another continent, and whether to replicate the competition that would be lost as a result of the merger, then you would require R&D facilities to be sold.
So is it then a jurisdictional problem that to solve the problem in America, you need to sell something in Germany, and that's under someone else's jurisdiction and can't be ordered here? Or
no, and typically, you know, there was sort of like Bayer Monsanto was an agreed upon remedy with the companies that was filed in court, and under that, parties can agree to sell things outside of the US, because they can really agree to anything. And a lot of times we will require, you know, we had a beer merger where the beer was made in a plant in Mexico. So the plant in Mexico had to be sold off along with the beer and the brand and blah, blah, you know, so this sort of like, what's the jurisdictional limitations doesn't really come into play, particularly if the parties are willing to remedy the merger.
Right, which leaves me still struggling, but I think I may just have to.
Well, I may
have to be left struggling.
But it is something that the agencies all recognize as a really important part of this cooperation. And sometimes, you know, we've had situations where teams are really looking at things differently, and they'll get, we have teams from the EC that come over and sit in conference rooms looking at documents to try to make sure that they're really interpreting the same facts the same way and seeing the market in a similar way, which then helps them come to similar decisions. There's also, I think it's also worth noting that there are a number of sort of multilateral organizations, and particularly there's one called the ICN, the International Competition Network, that really are geared toward discussing a lot of these issues and coming up with sort of some kind of like, they have a I'm sure you may actually be interested in reading their report on international cooperation and their best practices for agencies in how to do this, to come to decisions that don't conflict with each other. So that's something that's sort of, a really important thing within competition, is that people recognize the need to work together. I mean, I actually think, I don't know if Henri remembers, but we worked together on Microsoft, which was a long time ago. That's when we first met.
But I mean, just to jump on that, the instances where there would have been a contradiction between agency decisions, I've been working in that field for 30 years now, and I think I can think of 2 occasions in 30 years. So it shows that the system more or less works.
So on average, actually, the remedies one country would come up with and another would come up with aren't inconsistent, is what you're saying.
More than an average.
Right. I think, right. I would agree with Henri. It's extremely rare for them to be inconsistent.
Okay.
All right. And that's in large part because of sort of the goodwill that's been built up between all the agencies.
Well, maybe that's why I don't have the crisp example in my head of how an inconsistency works, because it's such a strange duck.
Professor Edlin, I could maybe give a small fraction of an example. We felt pretty confident on one deal about clearing in the US and clearing before the European Commission. And we thought, based on some of the questions that we were receiving from the Australian authority, that we might have to do a geographic remedy, that we might have to divest there. And the partner that was working on this case very positively sold this potential possibility to our client, and our client was very much against it. And I was nervous myself that maybe this will not be cleared. But in fact, the Australian authority did not require us to do some kind of geographic divestment there. I don't know if that had to do with the communication going on between the Australian authority and the European Commission or DOJ, but this was one thing that worked out in the favor of our client, who was adamant that they did not want to do this kind of piecemeal remedy.
So, Aaron, I can give you an example, very good example here in Brazil. International merge was Disney Fox. And in Brazil, they have to divest it through Fox Sport. So just in Brazil, they have to sell it. And was a completely different remedy because just in the Brazilian market, we had a problem with higher concentration. We were like coming from 2 players to 2 players. And that we require here at the tribunal that they should divest it through Fox Sports. So, and was just in Brazil.
Yeah, no, there clearly are different remedies in different places. Sometimes I'm still puzzled about the difference between different and inconsistent, but let's drop that for the moment. I learned a lot, and thank you all for helping me in that. So I have one more question about mergers, and then I was hoping to come to ask you about the digital economy, which is, everyone's favorite. My other question about mergers, so I was talking to a friend today who runs a hedge fund and actually covers stuff in equities in Brazil and Mexico and the US. And he's always, has the perspective, he's talking to business executives. And so his perspective was, well, why do you let these folks ever merge when they're competitors? He used an example from Brazil recently of two rental car companies, number one and number two, he said, that got to merge. But my question is, well, one, do we have do you feel comfortable with where the burden of proof is in your jurisdiction? And what is the burden of proof in your jurisdiction? I mean, the US, clearly the DOJ has to prove it's anti-competitive. The companies don't have to prove it's pro-competitive. Are you comfortable in Brazil and France with what the burden is and where is it? And what would you say to him?
Yeah, well, let me start, Henry. So I think that we're never comfortable with a big merge, and especially when we're talking about digital economy. It's also something that we are trying to discover what's going on. There is a lot of information asymmetry. We are not specialized in any kind of market, but just in competition, and we have to, go deeper in the investigation to try to learn a little bit about the market, so take better decision. And when we're talking about digital economy, it's much harder to understand what's going on, and this new era and the new things that are happening. For example, this case that rental car case that your friend told you, it was like, I think was the first one combined the second one or the third one, because the second one and the third one was very similar, but even was like 3 and getting 2, but there is no barrier to enter in this market, so they cannot raise in the price. The way out of this case, and we cleared this case, but we also applied a remedy. They are like divesting to a lot of cars and a lot of places in the airport. But in my opinion, those cases was kind of that case that the merger wouldn't affect so much the market, because it's very easy to create a new rental car. We have to invest in the brand, buying cars, and buying cars is also a very important business inside of this business. So there is no barrier to enter in this market. That was a specific, the specific thing about this case. And the burden of proof in Brazil is, in our law, they say that even each deal that raised significantly the market share has to be blocked. But there is some exceptions, and there is the exception. So when they create efficiency, when we can show that is good for the consumer. So, and in our guidelines about the merger and acquisition, the first step is define the relevant market. The second is calculate the size of the market. And the third one is analyze the probability of abuse of dominance, abuse of that power that are being created by the deal. So when we start to analyze that and see if there is rivals, there is barrier to entries, and even if the probability is high, we will analyze the efficiency if the efficiency can, be higher than the harm. And that's like in 30 seconds, the whole thing that we analyze. So when they come with the deal, we have to prove, or at least show them, that there is a high probability of harm. So when you do this, the high probability of harm, they have to come with the efficiency, and they have to show the efficiency is better than, is higher than the harm. And besides that, we have also the opportunity to apply some remedies and not and diminish the probability of the harm. So this is in a general way what we do in a merger and acquisitions here in Brazil.
So it sounds like you don't feel you've got the balance wrong or need new legislation or anything like that in dealing with these cases.
Yeah, no, I don't think that we need new legislation. We need like more economic tools. I think that our legislation is pretty good for the things that are happening in Brazil right now. Give also Kaiju very give us very let us free to also have a lot of power and analyze case by case. So this is very important, and I think that our law, it's very general in a sense that give us power to analyze and also create our soft law that can, lead the case and bring us to a better decision. I think that we need more maybe economic tools, understand better what is happening with the digital economy and the new thing, those new things. But in general way, I don't think that we need to change anything in our law to analyze merger and acquisitions.
Mm-hmm.
Aaron, could I jump in?
Yes, please.
So I think, yes, as you pointed out, the US DOJ needs to go to court to challenge a merger and specifically to block it. And we do have, President Cordero did a nice job saying you define a market, you look at this, and then you look at what does the concentration tell you about the market and in the increased concentration as a result of the merger. And in the US, we have, legal presumptions that can be rebutted, but they say at a certain level of concentration that the merger is presumed to be anti-competitive. And one of the things that's going on that's a combined effort of DOJ and the FTC is to take a fresh look at our merger guidelines that provide information to businesses and consumers and the courts about the ways in which we analyze mergers. And there's going to be revisions, that we've just recently asked for public comment about whether the guidelines, both the horizontal merger guidelines and the vertical merger guidelines, whether those should be revised. And that's really coming from the point of view of really an increased concern about increased consolidation across a number of different industries. So we're looking at the guidelines, and it's basically the effort is to say, are the guidelines analyzing mergers in the right way? Do they go along with the purposes of the antitrust laws? Are they really reflecting like the economic realities and the ways in which companies are doing business now? And so, that sort of is a bit of a fresh look, which is to say, there is concern about really increased consolidation and whether the burdens that the agencies face in challenging mergers, whether they really are sort of at the right place in terms of and sort of at the right level.
Thank you. So that it sounds like you think with a lot of experience at DOJ that this Philadelphia bank presumption does important work in these merger cases.
Absolutely. Because
there...
it's important for the judge to decide whether, the burden is met in the first place.
And so can you think of a case where, you think the agencies won it, but they might have lost if they weren't able to switch?
Well, I think there is a case we lost, which was the Sabre Fair Logics, where it was essentially the notion of a very nascent competitor being bought up by a company that really wanted to take them out as a competitor. But the judge didn't believe that it was a sufficient enough real, likelihood of being a real competitor. And, that's the kind of case that's sort of frustrating.
Gotcha. Okay.
So, Aaron, let me just add something that Patricia said, just because this is a very huge difference from Brazil. When you want to block an operation, we don't have to go to the judiciary, to go to the court. We just block here in Brazil. We don't go to the court. So that's a huge difference. We don't have to challenge the deal and convince the judge that we should block the operation. We just block. And if they don't like our decision, they have to appeal this to the judge. Did you know how many times the judge said, okay, Kaiji, you are wrong. Do it and consume the operation? None.
Yeah, he also told me you're the boss man down there.
Yeah, no, that's because, it doesn't make any sense because the judiciary takes so long in Brazil to, to finish the whole process that doesn't make any sense to still approve this operation 3-4 years later. That's the average that this case, maybe more than that, 5-10 years, more than that to finish this case in the judiciary. So nobody going to wait. The market will not wait this long time. That's why the people even don't go to the judiciary when the Kaiji blocked the operation.
Okay.
Professor Edlin, you asked if I can jump in as well.
Yes, please.
You asked about where burden of proof might be unclear or whether we're comfortable with the laws here. And I have one example. It might depend on sectors or exactly what it is we're talking about. We talked a little bit about sustainability and how is that coming into antitrust laws. And one example was a joint venture before the Federal Cartel Office in Germany. It's called MIBA Zollern. And they were trying to combine their hydrodynamic plane bearing businesses, which are important for wind turbines. And the Federal Cartel Office blocked the merger because of high market shares, switching costs, barriers to entry. And the parties appealed for ministerial approval because they said it's in the public interest. This will be good for know-how and for innovation. So these are maybe some reasons why we might allow a merger, even if it creates high market shares. And the Monopoly Commission said, no, you guys are doing the same things. This is still not going to help the public interest. But the German economics and energy minister, Peter Altmaier, said, actually, I think this is going to promote climate protection. And so he cleared the merger. And he had a couple of strange things along with that saying, okay, you must, MIBA and Zollern must operate this joint venture for 5 years. And you must invest 50 million euros in Germany. And this is very interesting in the sustainability context because different countries are doing different things. In the Netherlands, there are guidelines to say, oh, maybe cooperation is okay. But the FCO has always taken this, or has been taking a stance of no, just like you, President Cordiero, no, there's nothing against sustainability in our competition laws anyway, so we don't need new guidelines to do with sustainability. What I would say, though, is that it creates some lack of clarity. We don't know then whether a merger will be cleared or whether maybe the Monopoly Commission will clear it, even if it has been blocked, or whether the Economics and Energy Minister will do something different in this area.
Okay, thank you.
Aaron,
yes.
may I add something?
Please.
So you asked a question about digital mergers, and I think it's important to bear in mind a few things here. When you do an assessment of a merger, what you do is basically you try to forecast how the market is going to develop, and the difficulty with mergers in the digital industries is that you don't have a clear counterfactual scenario. You don't really know how the two companies are going to be combined in a way, how the market is going to evolve with the two companies combined. You don't know either how the market would have evolved absent the merger. And that creates a huge difficulty when you have to prove your case. So a significant impediment of effective competition in Europe, because you have to compare the way the market would evolve with the merger to the way the market would have evolved without the merger. And when you have a number of different counterfactual scenarios, that creates a difficulty to convince a judge eventually, even if your decision has been adopted in a positive or in a negative way. Then there's a second big difference in the digital industries. Is that the type 1 or type 2 errors change drastically. So these industries very often are subject to network effects. And in some of these counterfactual scenarios and in some of the scenarios linked to the merger, you may have a situation where the market is going to tip. And then you would have the creation of a very strong market power position. But that's just a likelihood. You don't know whether that's going to happen or not, but that means that the kind of balance between type 1 error and type 2 error that you have when you deal with mergers is completely changed in these industries. Hence the difficulty that the mergers pose for competition agencies when they review them in such industries.
Can you say a little more about that? That's very interesting. So you're imagining some market which perhaps is a winner-take-all market, I guess, that could tip, or one firm became dominant for a long time, or a platform did. And you're thinking that's typical of a digital market. And
that's something that you would find very often.
Where do the errors come in there? Can you spell that out for me a little bit? The two errors and how that pushes you in one direction or another?
So, you may have false positives or false negatives. In other words, when you would clear a merger thinking that it's not going to have any negative impact, but actually it's going to have a negative impact, that would be a false positive. Or I always confuse the two, but let's say that's one. And the false negative would be that you have prohibited a merger, but actually that merger, should it have happened, wouldn't have had a negative impact on competition. Usually, we give a benefit of the doubt to a merger. So we prefer to have false positives. But in the digital industries, with the possibility that markets may tip, what you find is that the cost of these false positives may be much larger than in other industries, and therefore that you may have to revisit the balance between type 1 and type 2 errors, false positives and false negatives.
I see. So your take is that in digital industries, you should be more conservative and less willing to allow a merger because you may end up tipping to the wrong technology.
For instance.
Okay. Yeah, well, I guess that I was sort of heading here anyway. I was thinking I was going to ask about mergers and then about digital economies, and I somehow confused the issue. I'm curious people's thoughts about how much is different with digital firms versus things we've seen for 150 years, railroads, telecom, newspapers. My friends Carl Shapiro and Hal Varian wrote this book 22 years ago, Information Rules, which kind of started with the premise, I think, that really it's not so different. But I wonder, is it so different? Do we need new legislation? I know we have this Digital Markets Act coming along in Europe that addresses some things. Or can the old antitrust rules handle digital markets just fine because nothing's new and really that different? I'll throw it out to anyone.
Okay.
Maybe can we start? Yeah, go ahead.
We'll do it. So I don't think that we need new legislation. As I said before, I think that we need new tools. And this can be the problem about analysis by price, efficiency, So a lot of those surveys that is related to digital economy, there is no price. We have another market that is completely dynamic. There is the winner takes all and all those things that we don't used to say we don't used to see in the other markets. So this can be a problem for us, for antitrust guys. And many of those things go to the quality of the product and also the service. And sometimes we don't know how to deal with that. We don't know how to measure that. And the decisions, are more kind of open without some numbers that we used to like very much. So, and give us more, insecurity about the decision. But that's not a problem of law. The problem is the economic tools and how to, to find the best decision of those cases. At least is how I see these things right now. And we see this discussion around the world. The people are trying to regulate digital markets, regulate a lot of sectors. And I don't think that this is a good answer. And this paradox, should I regulate right now, and stop some kind of innovation, or should I let it go and maybe we'll be late to trying to hold the companies because if you don't hold it right now, they'll be too big to fail. So that's the problem.
Okay. What is the European Digital Markets Act going to do, Henri? What changes will it bring in the world?
So I will get there, but first I think it's important to understand why we're speaking about the Digital Market Act. I think you have a number of issues with the digital markets. One is the fact that these markets may evolve very quickly, and they are technologically challenging for economists or for lawyers. So there's a skill gap for competition authorities, competition agencies when dealing with such industries. A skill gap and a speed gap, one. Second, as I was saying, these markets are evolving very quickly, and there is a risk that because of a certain behavior, a given market would be tipping, or an ecosystem would be expanding to an adjacent market, and the market would be tipping. And then if you arrive too late as a competition agency, you cannot solve that anymore. The damage has been done, the ecosystem has been enlarged, or the market has tipped. So based on that, and based on past experience, the European legislators found that there would be a case for proposing a new legislation that would provide the European Commission with new powers so that it could act more quickly if there were issues, or so that there would be some actions which would be prohibited on the part of platforms with, let's say, shorthand, a significant market power. So that's what was behind the proposal of the Digital Market Act back in December 2020. This draft legislation has been since then in discussion between I'm not going to bore you with the way legislation is discussed in Europe, but let's say that we don't have yet an adopted act, but the idea is to designate a number of platforms which would have a significant market power on some services as such. So that's a kind of decision. And once they have been designated like that, then they have a number of obligations where they cannot do a number of things, and they should do a number of other things. So one example would be when they intend to acquire another company, they would need to inform the European Commission that they intend to do such an acquisition. Or if they intend to do some self-preferencing in some instances, that's something which would be prohibited, etc., etc., etc. Now, when is it going to be adopted? It's going to be adopted probably in the first half or the second half of this year, and then it would be implemented in the following year. The one perhaps interesting thing about the Digital Market Act is that its legal basis is about the internal market, and it's not about competition rules. So you may have a situation where Digital Market Act would be implemented in parallel to competition rules being applied to the same companies. I don't know whether I have fully answered your question.
Oh, and just, on the US side, there's legislation that's fairly similar to at least part of what the DMA does, which is the Klobuchar-Grassley platform preferencing, self-preferencing bill that's getting a lot of debate.
And I guess the administration has no stated position on that right yet. Is that right?
I think that's true.
Well, then we won't get your position, I'm guessing.
I
won't ask.
Thank you.
I'd love to know, but I don't think I can find out here. So I won't pursue that. Do any of the panelists have questions for each other, I wonder? I should have asked earlier. We had a couple of good ones earlier. Well, listen, I have learned an enormous amount from all of you, and I bet the audience has too. So let me thank you all for having been so patient with my questions. I very much appreciate your indulgence.
These were very good questions.
Yeah, this was a fun discussion. I have to admire Henri and Sylvia, where it's a little past midnight already. So.
Oh, special thanks to those for whom it's past midnight.
Yes.
Without question. I've still got a blue sky here. Maybe I'm the only one.
Yeah, but it's pretty dark here.
It's
Okay,
quiet too.
well,
That might be a bit.
thank you all.
Okay, thank you.